Be seated. Good morning. Now's the time set for oral argument in cause number 1CACV18-0335, Rodney D. Olivier, versus Correctional Healthcare Companies, Inc. et al. For everybody's information, we are audio and video recording the proceedings as we always have. We're also live streaming them at this point because we're real upscale here. So barring any unforeseen circumstances or problems, you can critique yourself in those manners. Counsel, each side will be entitled to the normal 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left, and we would ask that you respect that. If you, when you are speaking, please remember that the 20 minutes is the limit. To the extent that you wish to have some rebuttal time for the appellant, you're certainly eligible for reserving some time and using it as is customary. But ultimately, it's up to you to reserve the time. We've reviewed the briefs and referenced the case this morning, so we are aware of the facts and issues. You might want to keep that in mind when you figure out how you want to distribute your time between advising us about those facts and arguing your issues. Counsel for the appellant, counsel for both, actually, when you come to the podium, I would ask that you each state your name and who you represent. And with that, the appellant may begin.
May it please the court, my name is David Abney, here representing Rodney Oliver. He pronounces it Oliver. I tried Olivier and various variations, and he always corrected me, so it's back to Oliver.
We did not want to offend, and we're trying to do it as we understood it, so thank you.
I think you used a far more elegant form, but he's just a more simpler person. The two issues, if I may, that seem to be most important are, was Rodney Oliver, a third-party intended beneficiary of the contract to provide inmate health services? And the second, most important issue is, did he file within the statute of limitations for breach of contract? The first one is, well, everything is based on the complaint, since they brought a motion to dismiss, and we'll take as true the well set out allegations of the complaint. He did a pretty good job for a handwritten complaint. It's legible and follows along. It's complete. My counsel across the aisle went through it like Sherman through Georgia at the trial court, though, and it was pretty much over. But he really did do the best he could to say that there's a contract here to provide health care services, adequate health care services to a small population, and he is a member of that small population. And therefore, under general contract principles, he would be considered an intended third-party beneficiary of the contract.
Is there anything other than Nahom and Ansley, I'm partial to Ansley, but it's on review, that supports the proposition that a would-be patient in a group like this, it can be a third-party beneficiary of a contract like this?
I cited some of the federal cases that seem to be in point dealing with prisoners.
Okay.
But Ansley and its related cases seem to be a pretty firm foundation for his situation.
Yeah.
It's not a large group. In every sense of the word, it's a captive audience, captive population, and this whole thing is set up so that very small population can get adequate, necessary, comprehensive health care services. Of course, ultimately you'll get into the issue of whether there was a breach of the contract. I laid it out the complaint states the facts in a fairly convincing manner that he had this consistent itching problem, and month after month it was misdiagnosed. Scabies is a very unfortunate condition. It causes intense itching, and if it's untreated long enough, it causes scarring, as he alleged in the complaint. In addition to the other problems, he was socially ostracized by the other inmates. They didn't want to get whatever he had, and who would?
Counsel,
and
doesn't
then he
that
was
sound,
subject to discipline.
doesn't that sound like a big tort issue?
Well, it's,
A big jumble of tort issues?
well, he provided, it was a very creative complaint. He had about 5 or 6 different claims, Arizona constitutional claims, and other common law kinds of tort claims, but they're gone because the statute of limitations for them is gone. There's no way I can argue that it hasn't expired. I mean, suppose I could make a continuing injury sort of thing, but it's really that we're down to the contract claim. And then for contract claims, you can allege and recover damages for physical problems that it causes you for physical injury. But he had more than that. He had more than the pain, the suffering, the anxiety, the mental distress, emotional distress. He was, among other things, socially ostracized and isolated within the population, and he was subject to discipline when he made it known that he thought he had scabies, and he wasn't getting treatment for him, and you know, the reaction of the prison administration, instead of saying, well, let's make sure you get the care that you're entitled to get, was to say, shut up and don't complain about it, and to discipline him for that, to isolate him for that. So he's got a range of damages that are traditional damages in a contract case. You know, it's not your usual in the sense of a business kind of contract, but in contract cases, there is a wide range of remedies that are available under the restatement and under Arizona law.
How do we determine what, because the allegation is that the contract obligated them to provide adequate, necessary, and comprehensive, I think was the language he uses.
Yeah, I think paragraph 75 and 77, I think is basically where he's getting to the heart of the problem there.
How do we determine what's adequate?
Oh, you don't.
Well, how would a trial court do it?
Well, testimony, from his testimony saying I had this condition, I hope that at some point he'll be able to get an expert witness to say that it was obvious from the symptoms that you did indeed have scabies way back when all this started.
And so the allegation or the proof would lie in whether there was that treatment or the services provided met the standard of care for doctors.
Well, standard of care for medical care. And what he alleged was, what was the phrase? Adequate, necessary, and comprehensive medical services. So you would have to, I think you need some sort of proof. I suppose he could try, depending on the situation, to say it's evident from the facts. I had this persistent itching, and they gave me treatment for fungal infection and other kinds of things that didn't work. And as soon as I got the proper medication and the proper amounts, it cleared up almost instantly.
Well, I'm not trying to trap you, but I'm part of my problem is that the ruling below was that, as I read it anyway, that the claims sounded in tort regardless of how he tried to characterize them. And so that since they sounded in tort, and it sounds like you're kind of agreeing with me a little bit that, well, you would have to use standard of care, which is to determine what's adequate. That's a malpractice claim. So why wouldn't the 2-year statute of limitations apply in that case?
Well, for any kind of direct malpractice claim or anything of that nature, it would. But when you're trying to define, well, you have a contract that says you need to provide adequate, necessary, comprehensive services. Well, if you're going to define what adequate is, you're probably going to need an expert to come in. Although, under these facts, you may be able to get away with it. This may be such a, this is going on for a long, long time. The treatment is provided that changes it, and I'm instantly cured. I think a reasonable jurors could say, well, yeah, this is obvious to us.
Every time I go into a doctor's office, I have to sign the little intake form, and it says they're going to treat me. Would that allow me to then sue under contract theory to say that there's a expressed or at least a written agreement that they're going to treat me, and that implies that they're going to treat me to a certain standard, and therefore I can sue 6 years later instead of 2 years later?
I will give you a solid maybe on that. And the maybe will take you way back in Arizona law to 1913, and it was the
Kane case.
Yes, the Kane case, which the Bean case in 1970 said it's still good law, and I think it's still good law. If it's just, I'm going to provide you services, I don't think you get a claim for breach of contract. But if they describe more of what the services are going to be, it's in the Kane case it was skilled and competent physicians and surgeons and competently treat. If it goes on to say that.
It sounds pretty close to adequate, necessary, and comprehensive.
Right. And I don't know if he knew about this case, but whoever helped him with it or his own inspiration, he provided enough to get him.
Why did that only show up in your reply brief?
Pardon me?
Why did Kane only first show up in your reply brief?
Well, like most of my reply briefs, I was replying to arguments they were making in the answering
Yeah, but
brief.
the ruling below is that this case sounded in tort, and therefore the 2-year statute of limitations applied. And
But I
Kane
did,
seems to be directly on point with your argument that this was a contract claim, so I'm wondering why we only saw it in the reply.
all I can say, well, two answers to that. One is I must have been replying to what they said specifically in the answering
They
brief.
cited Bean in their answering brief, and
Yeah.
Bean cited to Kane, and
Yeah.
so that you replied to that.
That's what
But-
took me back to it.
But it seems like it was frustrating to me that I didn't get to see their response to basically, it seemed like a new argument. You were finally addressing the sounding and tort argument in your reply.
Well, I thought I had laid it out in the opening brief fairly well, that this was indeed a contract action, and explained why, that
Well,
they were
you
breaching.
talk about the third-party beneficiary, and I agree, you do a
Right.
great job of explaining that, but it doesn't really get to the sounding and tort.
Well, the problem was, they were focusing on Bean and other arguments in the answering brief, so then I took a close look at Bean, and when I looked at Bean, I said, this is not what they say it is, and you went back to Kane, and then it became even clearer that my position was as strong as I hoped I laid out in the opening brief.
I agree with you that Kane has not been expressly overruled, but do you think that Kane has survived the Supreme Court's approaches to malpractice in other circumstances or in other professions?
Yes. If you're specific enough in your allegations, and if you have enough facts to support it, that it's not just, I'm going to provide you with medical services, but I'm going to provide you with specific things. And not just medical services, but adequate, necessary, comprehensive. Add some adjectives to it, and you fall right into Kane. And Kane's still good.
Except, you know what, I think that Barmat doesn't say that. I think what Barmat doesn't say, if you load up a contract with a bunch of promises to not behave negligently, it allows you to bring a negligence claim as a contract claim. What Barmat says is, we're talking about a claim, a duty that would not exist but for the contract. So, Barmat is an early 80s case, 10 years after Bean and generations after Kane. Don't you think that Barmat impliedly overrules Kane?
No. And I hate to see cases impliedly overruled
Yeah,
by anything.
yeah.
I mean, this business that you have of judging requires a great deal of precision, and sometimes courts are overly broad in their statements. And in that case, I think Barmat is overly broad. And it certainly doesn't apply. Nobody's ever directly overruled Kane.
Yeah.
106 years, it's still there, and I'm proud to say it's a great case, and it should be enforced. And I
When
hope
was
you
the last
agree.
time it was cited in Arizona?
Pardon me, Your Honor?
When was the last time Kane was cited in an Arizona decision?
I suppose.
Not that that's necessarily telling, but.
I suppose I could do a Westlaw search into briefs and to find out when it was last cited, but certainly it was cited by me not too long ago.
And I saw your brief when I looked at that.
There you go. Thank you, Your Honor.
Question.
Westlaw is doing a marvelous job with getting the briefs up there. Whatever you write now is preserved for immortality, for whatever reason. I don't know. This seems like a decent stopping point to me if there's no more questions right now.
None for me.
Very good.
Okay.
Good morning, Your Honors, and may it please the Court. My name is John Quinn, and I represent Defendants in Appalachia Management and Training Corporation.
How are you guys going to divide your time? Or maybe I just interrupted you before you told me that. Sorry.
I'm going to spend the lion's share depending on questions, and then I believe Denise just has a little bit at the end. So probably 15-5, but maybe not that.
Are you going to cover different subject matters to allow us to know who to ask questions of?
Yeah, I'm primarily going to focus on the sounding and tort/contract argument with just a little bit on the third party, and then Denise is primarily going to take the third party argument.
Great, okay, thanks.
There's been a lot of talk back and forth when counsel was up earlier about the Kane case. And if I recall reading, when I read that case in preparation for today, it isn't distinguishable. The reason it hasn't been overruled is because Kane involved a lawsuit from an employee was an employee contract, which contained a provision that said the employer will provide competent, et cetera, healthcare services. When that didn't happen, he sued his employer for breach of contract, and the issue in that case was statute of limitations. It didn't involve one of the situations that we have in this case, which is one of those special relationships that has been specifically recognized by common law. And the importance of these special relationships.
And what would that be? What special relationship?
I apologize, Your Honor. This is the jailer-prisoner special relationship. It's found in Restatement 2nd, 314A, and then was recognized by Fleming versus State Department.
You don't think this is just as a medical malpractice lawsuit?
Well, I think it touches on both. But depending on the allegations of the parties, we've taken the position that the way the complaint is alleged, there are no allegations against MTC that MTC was required to provide health care services. The only allegation against MTC appears in paragraph 79, which states MTC breached his contract to operate the Arizona State Prison System. All the health care related allegations fall upon CHC, who is contracted to take care of those services, and that is in a different paragraph.
What does MTC do versus CHC?
MTC is in charge of the entire management, from my understanding. So they do more of the day-to-day, prison guards, the officials.
Total operation of the prison.
Correct.
And CHC?
Is subcontracted.
That does medical?
Correct.
So get back to, because I'm not tracking you, why would that special relationship, assuming it exists and is recognized in Arizona law, why would that distinguish Kane?
Well, because in this case, we have a plaintiff suing someone that is owed those duties as a result of a special relationship, whereas that wasn't the case in Kane. And I think it's important because those special relationships exist, the common carrier, landlord-tenant, all of those special relationships exist for public policy purposes. And in exchange for that recognition, there's a certain cutoff when it comes to attorney's fees and whether you get the extra 6-year statute of limitations. You don't get both. It would take into its logical conclusion if we didn't recognize a cutoff, and if we didn't, have any specific promises, anytime someone got in a bus accident, they get 6-year statute of limitations simply because, they paid their $1.50 and got on the bus. And I think Barnett makes clear, for public policy reasons, we've never extended the law that far.
But so your argument is that the special relationship between a jailer and an inmate should be treated differently by the law than the special relationship between a doctor and a patient?
I think it should be treated the same.
Well, but,
Okay, so you're arguing, I'm sorry.
no, go ahead.
So, but your concern is because MTC doesn't have the doctor-patient relationship, you have the jailer, so
Okay.
the base of your claims. All right, so I track what you're saying now. So,
But Kane was doctor-patient.
It was, but the suit wasn't against the doctor.
Well,
If I
it was
recall.
like, if I sue Banner, that's a medical malpractice case. Right?
Which one was that, Your Honor?
No, that was a hypothetical
Oh,
case
sorry.
involving hypothetical injury. But, I mean, if I sue a hospital that employs the doctor, that's going to be a medical malpractice claim.
Correct. And even in that instance, that's still an implied duty by law. It's just it's given the moniker professional relationship versus a special relationship recognized at common law. The application of where the duty comes from, the public policy reasons behind the duty is the same.
so when CHC gets up, she's going to argue or tell us that the special doctor-patient relationship applies here and gives him an independent grounds for suit. So therefore, it would be a contract. Since you don't have that, you're arguing the jailer-patient relationship,
Yes, Your Honor.
or jailer-prisoner, sorry.
But I'm still not seeing how that should be different than the relationship in Kane.
Well, again, I mean,
Doctor-patient, jailer-inmate.
and I'll use a different case that I think is more applicable. I think Collins is directly on point. I know that case involved an attorney malpractice, which we're dealing with a professional, but it was a suit by 2 former clients against their former attorney, which is, a plaintiff suing someone that had a special relationship or professional relationship. The contract in that case provided that the attorneys would provide reasonably necessary legal services. Well, when the attorneys didn't file suit and the former client sued them for malpractice, they alleged they had breached that. The Collins court stated that that reasonable necessary language was nothing more than the general promise they would have been owed that would have been implied by law in these special relationships.
So that was a Barmat case.
That was a Barmat case, and that's Collins versus Miller. I think that one is more directly on point than Kane, and I think even Bean recognizes, look, in a situation where someone is suing their employer or someone suing not the malpracticing or negligent party, the Kane rules would still apply. But that wasn't the case in Bean, because Bean also involved a direct suit against the doctor.
But in Kane, the employer was running the hospital. I mean, it was like suing Banner. There was an element of the employee-employee relationship which created the contract, but his claims were all indistinguishable in my mind from malpractice claims against the hospital. I mean, he's alleging that they didn't meet the standard of care in providing the services that he received. So how do we get rid of, how do you get around that?
Well, I think one of the ways.
I mean, there was malpractice claims in 1908 and 1912 that gave rise to an independent duty that they recognized in Kane, and they're specifically deciding, no, the statute of limitations for tort doesn't apply here, it's a contract. So how do we get where you want to go here?
I think one of the ways to distinguish it is, at least as the allegations apply to us, there is no, that language, the necessary, competent, proper medical language that's pulled from Kane, there's no allegation in this case that applies to MTC. And secondly, because I know that's probably not, the exact answer you're looking for. Secondly, I think it can turn on it almost implies a heightened standard in Kane, something more than what the regular standard of care would apply. Something more amounting to a more specific promise. Again, I don't think that's the facts here.
Do you think Kane has been impliedly overruled? We'll ask the same question Judge Johnson asked your opponent. Impliedly overruled by Barmat?
I would say so. The only time I've seen Kane is in dicta, in which they say, if you're suing your employer, this still works. But we have Collins, Long, Kyojian, we have all these cases, and if Kane still applies, then all those cases are arguably wrongfully decided. We'd be getting rid of 40 years of case law if Barmat didn't overrule, at least impliedly, Kane. With the little bit of my time that I have left before I hand it over to Denise, I want to stress one thing, and the reason we've made a distinction with the specific allegations to MTC versus the specific allegations to CHC is, as Mr. Abney brought up for the first time in his opening and reply brief, there's all these claims that the same analysis applies when it comes to the third-party beneficiary part, whether to test whether he stated an actual claim based on the complaint. The only allegations against MTC are that we operated the prison. There's no allegation that we were in a mutual contractual relationship with CHC. There's no allegation that we're a party to the CHC's contract with the ADOC. So there's two separate...
Wait. Say that last sentence again.
There's no allegation that MTC was also a party to the CHC contract. So we have two separate contracts, one contract for MTC to operate, the other contract for CHC to provide healthcare services. There are no allegations that would meet the test, the three elements of a third-party beneficiary claim in regards to the allegations asserted against MTC. In particular...
What cases support the proposition that in a healthcare setting, as was the present in Nahom and Ansley, we don't have a third-party beneficiary situation? Is there anything going the other way in that context?
I hate to give you the trivial, but it depends. It depends if we're dealing with a private services contract or a public services contract. And one of the cases council cited was a case called Flagstaff versus Flagstaff versus Sullivan. And in that case, at the end, they refer back to the restatement, which says when you're dealing with a entity that contracts with a government for public services, unless the contract specifically has some evidence or provision that would highlight a party could bring a claim based on that contract, there is no third-party beneficiary status.
And what kind of contract was that in Flagstaff? Do you remember? I can look it up if you don't know it. Okay.
Not off the top
Okay.
of my head, Your Honor, I'm sorry. I believe it involved healthcare claims asserted under the Hill-Banner Act, in which Flagstaff Medical had pulled a lot of welfare-oriented claims, and there was a class action suit to enforce those claims under the hospital's contract with the government to provide those benefits, if I recall. But that's loosely how I remember it, but I think that's the case.
Okay.
And with that, I will yield my remaining time to Denise, unless the court has further questions.
Thank you, counsel.
Good morning. May it please the court, my name is Denise Troy, and I represent Correctional Healthcare Companies, defendant appellee in this matter. And I'm going to concentrate on the third-party beneficiary argument because I believe Mr. Quinn has very adequately handled the tort issue, though I would add one more thing to it. When Mr. Abney was standing up here, he mentioned the type of damages that his client suffered: pain and suffering, ostracism, all tort claim damages. These are not contract damages, which show that this is a tort claim, not a contract claim.
Can you have a contract and simply refer to various things that might come up, and by that bring them in as contract issues? Do you understand what I'm saying? If you have a contract to provide health services, and there's a certain standard that applies to the people providing those services, does the simple fact that they are providing those services make their misconduct contract breach rather than a tort?
Assuming that there is the plaintiff is a party to the contract, because no, because this is a duty implied by law to provide proper medical care that meets the standard of care. And to prove their claim, they're going to have to prove that CHC and its employees breached the standard of care, which is a tort claim, and that claim is now gone.
If the allegation were, and I realize it's not, that the contract explicitly provided that he would be provided a MRI when necessary, and part of his allegations were they didn't provide the MRI and I suffered all these damages as a result of it, and they should have provided the MRI. Would we get rid of the entire claim, or would we allow him to maintain at least the breach of the MRI claim?
I think you would be correct in saying that the breach of the MRI claim, because it's a definite service they agreed to provide. But what the contractual damages flowing from that are maybe additional costs incurred. They would all be economic damages. They wouldn't be tort damages, pain and suffering, because those are not contract damages.
And again, I'm not trying to trap you either, but if we would allow his claim for a provision of MRI to say that was a contractual claim, why can't we say then that is the agreement to provide for adequate care is a contractual claim?
Because that's a very amorphous term. It's not a concrete term. Adequate care is something that is based on the standard of care, which again is a tort concept, not a contract concept. And it's not a concrete promise. It's a we'll do the best we can type promise, which is, so
it goes back to the question I was asking, which is in order to define what adequate care is, you have to look to standard of care, and therefore you've kind of now converted into a tort as opposed to.
Precisely.
We don't have to look to that to define what an MRI is.
No, you don't. Again, to take your analogy a little further, if the contract said you are to provide health checkups every 6 months, and they didn't do it. That is a concrete term of a contract. But here we're dealing in generalities. And
But
he
if it said
allowed,
health checkups no less than every 6 months as necessary, then you would say that's a different kettle of fish.
that's a different kettle of fish. So let me go on to the contract issue. The allegations in, yes, and just so you're clear, correct, and correct care goes through iterations of names, so I can never remember which one it is. CHC had a direct contract with the state of Arizona to provide medical care at the prison. And it was not in contract with MTC, so
Okay.
it was a separate, totally separate agreement. And plaintiff has simply alleged that he is a third-party beneficiary of this without showing how he's the intended beneficiary of the contract, why he is the intended beneficiary of the contract, saying that there is a small group of people who are intended beneficiaries without defining what it says in the contract, rather than say that they promised to provide adequate health care, is simply insufficient to state a claim under contract against my client.
Boy, I'm having a hard time with that. Because he's an inmate. Your client contracted to provide medical care to inmates. What more does he need to show to get within that window?
He needs to show that the contract required them, that he was a third-party beneficiary under the contract. You don't become a third-party beneficiary automatically just because there's a contract that exists that might benefit you in some way, shape, or form.
But this was expressly intended to provide medical care for inmates. That included him. But that was the purpose of the contract, wasn't it?
Isn't that what the word intended means? He's an intended beneficiary under the contract?
We don't know he's an intended beneficiary under the contract, Your Honor, because we don't have the contract.
But you just conceded that the contract obligated your client to provide medical care for inmates, to inmates.
To act on behalf of the states and the state of Arizona in providing medical care to the inmates. And if you were to take this as far as it's going here, every prisoner who was in a prison that had a private health care provider is then an intended beneficiary who has a 6-year statute of limitations to bring a claim against.
Well, that's a different matter.
That's a different issue.
Different
We're just
kettle of
talking about,
fish.
can he sue as a third-party beneficiary right now under contract, not whether which statute of limitations applies depending on whether it sounds in tort or not. That was what Mr. Was it Gallagher or Quinn? Quinn addressed.
There's nothing in the complaint that shows he was an intended beneficiary, other than his statement that CHC agreed to provide adequate health care to inmates. It doesn't say that it was specifically to him. There's nothing to show that
he says I was an inmate in there, and he alleges he was an inmate in the prison system.
Yes, he does.
What more would have been required? If the city of Phoenix enters into a contract and provides a certain benefit to all city bus drivers, is him being a city bus driver not sufficient then to get the benefit of that contract?
I'm not sure I understand the analogy, or that's.
There are groups. We refer to groups in group names. For instance, we have inmates. We don't have to name all of the inmates. We don't have to have a forever list of them that goes on and on and on. They provided a service to inmates, right? They're
Correct.
contracted to provide a service to inmates.
Correct.
And does he or does he not have the right to claim a benefit in regard to the contract for those benefits?
I believe he does not. I do not believe that he can allege that he is a third-party beneficiary under the contract.
But he can allege that he's an inmate
He can allege that he's an inmate.
and that the benefit was to flow to the inmates.
He can allege it, yes.
Okay, so the contract they entered into wasn't for the benefit of inmates. Is that what you're saying? It was not intended to provide a benefit, a healthcare benefit to inmates.
I do not believe under the terms of the contract it was intended to provide the benefit they're seeking. And I'm out of time.
Thank you.
Thank you.
As I was sitting there listening, I was contemplating many things. and one of them was Barmat. And that reminded me that what I confronted was a cascade of cases that dealt with legal malpractice, Barmat being the leading one. And the problem in Barmat was really the implied contract and implied covenant. And here, we're not talking about an implied contract or implied covenant. We're talking about an express contract to provide adequate, what does it say? Adequate,
Comprehensive.
comprehensive, proper healthcare services. And I know that language is a little bit generalized. However, if you take a look at Kane, a case that has been long honored in Arizona jurisprudence and frequently cited,
Well, go ahead.
long honored at least, the
Not
cause of action was
dishonored.
breach of contract to furnish skilled and competent physicians and surgeons, and to competently treat the plaintiff's injuries. That's pretty broad language, and it's really not that much different from what Rodney Oliver was able to put into his complaint. We should fit within the Kane doctrine, and I don't think Barmat has really dealt with the Kane issue for the reasons when I was first on my feet, and now that I've been refreshed by a period of contemplation, for the additional reason. They were talking about the implied covenant between the attorney and the client, and that's really not what we're dealing with here. In case after case that they cited, the same thing came up. It was the attorney-client kind of problem, but that's not what confronts us.
But Barnett does say broadly that where there is a duty arising under other law, you don't rely on the contract for it, though. I mean, so I agree with you that the actual facts are a little narrower than what we're dealing with here, but the broad statement of law seems to be broad enough to encompass it.
Well, I think that's why when a plaintiff goes to the court, is confronted with a smorgasbord of choices, causes of action, claims for relief that can be asserted, and he presented a smorgasbord. But the first ones are gone because of the statute of limitations. I can't in good faith argue those, but the one that's remaining is this breach of contract. Actually put that forward fairly well. And it's enough to get him through, that he would get back in the court and have a chance to say, yeah, there was a contract here, they breached it, to get him within the 6-year statute of limitations. And give them a chance to go forward. Now, part of the problem is we sort of conflate a little bit the kind of damages you can assert. And in pages 26 and 27 of the opening brief, that's one issue I think I dealt with fairly well. You get a broad range. If you take a look at the Raji, you get, which is contract 18, you get the damages that were caused in fact. If you drop down to the restatement second of contract, section 347, comment C, which is of course engraved in our memories, the general principle is that all losses, however described, are recoverable. And there's case law galore that says you can get these kinds of damages that he's trying to get in a breach of contract case. Maybe not your typical situation, but sometimes you get push comes to shove. And here he has done the best he could to allege, given his limited resources and capabilities, a complaint for breach of contract, and he did it. Maybe not artfully, but he did it. I can, of course, digress for hours, but I would like to return my time to the court if there's no further questions.
None for me. Thank you.
Thank you.
Thank you, folks. We appreciate the argument today. We appreciate the positions. And we're going to take it under advisement at this time, and we'll rule in due course. Thank you.
David? No one under? Yes.